If you're right, Mr. Dellinger, it's certainly an odd way in the Second Amendment to phrase the operative provision. If it is limited to state militias, why would they say the right of the people? In other words, why wouldn't they say state militias have the right to keep arms?
Mr. Chief Justice, I believe that the phrase the people and the phrase the militia were really in sync with each other. You will see references in the debates. The Federalist Farmer uses the phrase, the people are the militia, the militia are the people.
If that's right, doesn't that cut against you? If the militia included all the people, doesn't the preamble that you rely on not really restrict the right much at all? It includes all the people.
Yes, I do believe it includes all the people in the sense of verdugo requites, all those who are part of the polity. What defines the amendment is the scope and nature of the right that the people have. It is a right to participate in the common defense, and you have a right invocable in court if a federal regulation interferes with your right to train for or whatever the militia has established. So that military forces.
I don't see how there's any contradiction between reading the second clause as a personal guarantee and reading the first one as assuring the existence of a militia, not necessarily a state-managed militia, because the militia that resisted the British was not state-managed. But why isn't it perfectly plausible, indeed reasonable, to assume that since the framers knew that the way militias were destroyed by tyrants in the past was not by passing a law against militias, but by taking away the people's weapons? That was the way militias were destroyed. The two clauses go together beautifully. Since we need a militia, the right of the people to keep and bear arms shall not be infringed.
Yes, but once you assume that the clause is designed to protect the militia, surely it's the militia that decides whether personal possession is necessary. I mean, Miller, what makes no sense is for Miller to require the arm to be militia-related if the right is not. And the key phrase is bear arms.
Well, do you think the clause is the second clause, the operative clause, is related to something other than the militia?
No, I think the second clause, the phrase "keep and bear arms," when bear arms is referred to in a military context. That is so that even if you left aside,
it had nothing to do with the concern of this remote settler to defend himself and his family against hostile Indian tribes and outlaws, wolves and bears and grizzlies and things like that.
That is not the discourse that is part of the Second Amendment. And when you read the debates, the congressional debates, the only use of the phrase "keep and bear arms" is a military phrase, and that is
Blackstone thought it was
otherwise.
important. Blackstone thought it was important. He thought the right of self-defense was inherent, and the framers were devoted to Blackstone. Joseph Story, the first commentator on the Constitution and a member of this court, thought it was a personal guarantee.
My question is, if that is correct and keep should be read as, in effect, an independent guarantee, then what is served by the phrase "and bear"? In other words, if the people can keep them and they have them there for use in the militia as well as to hunt deer, why do we have to have a further reference in there to a right to bear as well as to keep arms? And my point is, it sounds to me as though "keep and bear" forms one phrase rather than two, but I want to know what your answer is to that.
The way I would read it, Justice Souter, is that "keep" is really talking about private possession in the home, and the way that I would look at it is in order to exercise, for example, an opportunity to hunt, that you would need to bear the arms as well. And I would point you, I think it's a useful point.
But wait a minute, you're not saying that if somebody goes hunting deer, he is bearing arms, or are you?
I would say that, and so would Madison and so would Jefferson, I would submit. They use
somebody going out to, in the 18th century, someone going to hunt a deer would have thought of himself as bearing arms?
government.
If you were thinking of the people, what those words meant when the Second Amendment was adopted, it was males between the ages of, 17 and 45? People who were over 45 they didn't serve in the militia?
Well, certainly there were many people who were not eligible for militia duty or not subject to militia service who nevertheless were expected to, and oftentimes did, in fact, have guns.
Which shows that maybe you're being unrealistic in thinking that the second clause is not broader than the first. It's not at all uncommon for a legislative provision or a constitutional provision to go further than is necessary for the principal purpose involved. The principal purpose here is the militia, but the second clause goes beyond the militia and says the right of the people to keep and bear arms. Now, you may say the kind of arms is colored by the militia, but it speaks of the right of the people. So why not acknowledge that it's broader than the first clause?
Oh, we do acknowledge that, Your Honor.
Why have the
jury clause?
Well, if,
and they didn't
if
do it
the
with
amendment
respect
is
to the Second
intended, at least in part, to protect the right to self-defense in the home, how could the district code provisions survive under any standard of review where they totally ban the possession of the type of weapon that's most commonly used for self-defense, and even as to long guns and shotguns, they require at least what the code says without adding a supposed gloss that might be produced in a subsequent case, that even as to long guns and shotguns, they have to be unloaded and disassembled or locked at all times, even presumably if someone is breaking into the home.
Well, Justice Alito, let me answer the question in two parts if I can, because I think the analysis of the trigger lock provision may well be different than the analysis of the other provisions. With respect to the trigger lock provision, we think that there is a substantial argument that once this Court clarifies what the constitutional standard is, that there ought to be an opportunity for the District of Columbia to urge its construction, which would allow for a relatively robust self-defense exception to the trigger lock provision. And this Court could very well, applying Ashwander principles, allow for that kind of interpretation.
I don't understand that. What would that be? That you can, if you have time, when you hear somebody crawling in your bedroom window, you can run to your gun, unlock it, load it, and then fire. Is that going to be the exception?
Now focus on the handgun ban. As I read these 80 briefs, and they were very good, I mean really good and informative on both sides, and I'm trying to boil down the statistics where there's disagreement. And roughly what I get, and don't quarrel with this too much, it's very rough, that 80 to 100,000 people every year in the United States are either killed or wounded in gun-related homicides or crimes or accidents or suicides, but suicides are more questionable. That's why I say 80 to 100,000. In the district, I guess the number is somewhere around 200 to 300 dead, and maybe if it's similar, 1,500 to 2,000 people wounded. All right. Now, in light of that, why isn't a ban on handguns, while allowing the use of rifles and muskets, a reasonable or a proportionate response on behalf of the District of Columbia?
Because, Your Honor, for the same reason it was offered by numerous military officers at the highest levels of the U.S. military at all branches of service. Writing in two briefs, they agree with us that the handgun ban serves to weaken America's military preparedness, because when people have handguns are military arms. They're not just civilian arms.